Coming tonight to spend some time and listen and learn a little bit about estate planning. My name is Josh Boehm. I'm an attorney with Adair Law. We have offices here in Manhattan and in Junction City, but we serve clients throughout the state. In addition to estate planning, real estate, and some business law matters, we also have attorneys who are focused exclusively on criminal defense and family law matters. So again, this is going to be an introduction to estate planning. We're going to cover some of the basics and important parts and considerations that you should have as you go through this process. So the first thing to know is that this is informational, educational only, and is not legal advice. So it's important that you consult with an attorney regarding your specific situation. Facts matter and are an important part of the estate planning process. So no attorney-client relationship is created by this presentation. So the first question really is, what is estate planning? So estate planning is the process of organizing and designating how your assets will be distributed upon your death. It's about communicating your wishes to loved ones, family members, and the professionals who helped you craft it and help you manage your affairs, accountants, financial planners, attorneys, bankers, etc. Whoever is an important part of your day-to-day life. And just like in life, communication is important. It becomes particularly important when choosing to provide for beneficiaries differently. If maybe children are getting their assets in a different manner or different type of assets, or if you're electing not to provide for a beneficiary at all. And estate planning also, oftentimes more importantly, controls what happens when you're living. If you have a stroke, suffer from dementia, or another health illness where you're incapacitated or unable to handle your own affairs, your estate plan is going to control and provide guidance to your loved ones and family members how to handle your affairs. An effective plan ensures a seamless and smooth transition from you, both during life and after, and how your assets and legacy is handled. This is done through a combination of various legal documents that we'll discuss each in brief tonight, the importance and the role that each one plays. And again, we're trying to provide clear directions for the management of your estate and for healthcare decisions. Again, not just how you're cared for during your life, but final disposition of your body after life as well. Again, why is it important to have an estate plan? Again, we want to make sure that your wishes are carried out, that people are not worried about how to handle things, where things are, what would mom or what would dad, what would my brother have wanted. We're going to try and avoid family disputes. This is probably everyone's number one objective. We want to ensure the seamless transition from one generation to the next, from one family member to another. This is all about communication. A well-drafted plan ensures that your assets, no matter their form, financial accounts, digital assets, real estate, your personal collections and belongings, are distributed according to your wishes. I won't stop harping enough on this, but this is all about communication. It's even more important because you are no longer here to communicate your wishes. It has to be written down. The more you share and talk about it with family during your life, as uncomfortable as that may be, the easier this process becomes. Hearing it straight from mom, dad, their sibling, their uncle, aunt, cousin, whoever may be playing those roles or assisting you or your family through this process, hearing it straight from you during your life makes these decisions, these disputes, much easier for everyone to handle. You may not be happy with the results, or what your decisions or choices were. But if it's clearly communicated, again, during your life and in the written documents that we draft and create for you, makes it a lot easier. Now, that's where we come into this protection for loved ones. Someone is going to be tasked with carrying this out for you, whether it's a child, a sibling, a spouse, whoever it may be. Again, particularly if you're providing for beneficiaries or heirs differently, or not providing at all, writing it down really helps them give something to rely on. It takes some of that discretion away from them. This was mom's wish. This was Uncle Bob's wish, whatever it may be. Part of the estate planning process is going to be talking about understanding your family dynamics, and what legacy you want to leave. What goals are you trying to achieve? This isn't just about making sure that, this person gets 30% and this person gets 20, et cetera, et cetera. This is about what are we trying to accomplish with that distribution? We try and anticipate those likely outcomes and scenarios that we can and provide for those as part of the plan. Here we'll start to get into some of the different components of an estate plan and the documents that go into creating and drafting that. So the first one that most people are familiar with is a will. And a will is an important document. Everyone should have a will as part of their estate plan. Next, we have trusts. There's dozens and dozens of kinds of trusts. The two most common and in most basic forms are grantor trusts in either a revocable or irrevocable form. And the titles speak for themselves. An irrevocable trust comes with significant protections because you're giving up control. The initial drafting, that's how it's going to be. It's going to exist in that form or fashion until the trust terminates. Next step is the living trust, again, also known as revocable trusts. Those trusts are documents that you can amend and edit and are what most people utilize. Powers of attorney come in two forms: financial and healthcare. Advanced directives cover such things as living wills, do not resuscitate orders, and then finally beneficiary designations. So these are account ownership or contractual designations, also could be called pay on death, transfer on death, things of that nature, depending on the type of account or the property that they convey. So again, the first document we'll talk about is a will. This is probated. So this is something that is submitted to the court and carries out your last wishes. This is a formal document. The general form of a will has been around for a long, long time. The will is a great estate planning tool, though. And again, every estate, I can't stress this enough, should have a will. They're very easy to do. Once they're created and drafted and signed, they don't require anything else. It's a catch-all, it's a safety net for your estate plan. If there's an error or a failure on a beneficiary designation, or if there's a trust that isn't funded or an asset that didn't get moved somewhere, the will is there to catch all those assets, to catch those mistakes, to catch those forgotten things, and make sure that your wishes are still carried out. So in Kansas and most states, but again, this is a Kansas specific presentation, a will has to be done in writing, signed by you, and witnessed by two people who are not beneficiaries of that will. They can't be related to you either. And that witness has to sign the document as well. If you do not have a will or other estate plan, then Kansas law has a process we'll talk about called intestate succession, And that law is going to determine the distribution of your assets that may or may not align with the choices that you would make. Again, that's why it's important to have a will and these other documents in place so that it's your wishes, not the generic form found in statute that gets carried out. Trusts, again, trusts come in dozens of forms. There's insurance trusts, marital trusts, AB trusts, Q-tips, all sorts of other forms. Again, most people will utilize a living or revocable trust, something that they create during their lifetime that they move assets into. They can amend it, they can change it, and typically you will serve as the initial, or you and a spouse will serve as the initial trustee of your trust. There is also testamentary trusts. So these are created upon your death through the probate process, and the terms of these trusts are found in your will. There are instances where these can be useful tools. Sometimes they can be helpful in situations where high conflict is anticipated. Probate is a great tool for that generally. We'll talk about that more a little bit later. Testamentary trust can sometimes be useful when there's minor children and you want to ensure that there's oversight of the assets, that assets are protected for them. The easiest way I found to talk to people about trust and explain what a trust is it's a bucket. And that bucket continues in the same form or fashion during your life seamlessly through after your death. It holds all the assets that you put into it, and the trust document serves as the written direction and determines how, when, why, by whom, to whom different assets are pulled out and withdrawn from the bucket, and what assets and when. By keeping everything in one bucket, there's almost no lapse in control of the assets in that bucket from your passing to the next. The trust designates a successor trustee or trustees, one or more people to serve and take over and serve in that capacity after your passing. Sometimes we'll designate and have someone take over before your passing or serve with you during your life. That allows you an opportunity to work side by side and make a smooth handoff from one generation to the next and ensure that they understand what you're trying to accomplish with the trust, where the assets are, make introductions to, again, perhaps accountants, attorney, financial planner, those other important people in your life who have helped guide you and grow your estate, grow your business, your ranch, whatever it may be. Powers of attorney are the next document. And again, these grant someone the authority to act on your behalf regarding the specific powers that are laid out within those powers of attorney. They come in two forms: financial power of attorney or a healthcare power of attorney. Financial power of attorney is also often referred to as a durable power of attorney. The easiest way to think of these as, again, these are documents that allow someone to act in your stead. And the financial power of attorney extends beyond often what we think of as traditional financial affairs. Yes, it allows someone to pay your bills, but it also allows access to PO boxes, maybe to an email or other digital account. In the powers of attorney that we use, we have identified 38 specific instances where the power of attorney can be utilized for financial affairs. Things like access to safety deposit boxes, allow for the filing of your taxes, to allow for elections for Medicaid or Medicare, to make decisions related to health insurance. Maybe you need to change supplement policies. Maybe you need to obtain long-term care insurance or something else. It allows your power of attorney to do all of those things, sell a vehicle, buy a vehicle, things like that. And those specific powers can be taken away if there's something that you don't want done. Again, a good estate plan is customized to what your objectives are. What are you trying to accomplish? This is your last written instruction in a way to communicate to the future generations or to your beneficiaries, really what you try to accomplish during your life. And then a healthcare power of attorney allows for someone to make an election related to your care when you're unable to. It could be during a surgery. It could be during a moment of incapacitation after an accident, after you've suffered a stroke, dementia, any number of situations where it may be necessary for someone to make a decision. Again, it's able to provide them guidance. You can put specific procedures in there if you like that you do not want to be performed. If you have a objection to a certain form or type of procedure, you can make sure that that's communicated in writing. Again, both with these powers and I would point out with trust, and it's right in the name, you have to trust the people who you are granting these powers and decision-making ability to. And the more you can communicate to them and share with them what your feelings are on different things, the better they're going to be able to make decisions and reflect the choices that you would want to be seen. The final thing that healthcare power of attorney can do is typically, other than this one instance, powers of attorney cease with your passing. So if you've granted someone the power of attorney, that's not a substitute for a will. It's not a substitute for a trust if that's right for your situation. It's not a substitute for some other manner of disposition. No, power of attorney isn't going to be able to sell your house, get rid of this stuff in your house, share your bank accounts, anything like that once you pass. The one exception is the healthcare power of attorney does allow you to make direction in writing in that document to whoever you name related to disposition of your body. So it allows them to make a decision of, are your organs going to be donated? Are they not? Are certain ones going to be donated, others not? Do you wish to be embalmed, buried, cremated? Do you want your body donated for medical research? Any of those decisions can be laid out and designated in your healthcare power of attorney. Advanced directives come in two main forms. Again, both a living will and a do not resuscitate order. And at their core, they really are that. They're directions that you have given and written in advance to the individual or individuals who hold your healthcare power of attorney and your treating medical professionals as to how you wish to be cared for if you are unable to give those instructions. It can cover, so living will address terminal illness, can address vegetative state, and it is another place that you can put additional instruction or supplementary instructions related to disposition of your body for that healthcare power of attorney and for those medical professionals to carry out. When dealing with a terminal illness or vegetative state question, those decisions are going to require two physicians, one of whom is your treating doctor. So if it's heart disease, your cardiologist; if it's cancer, the oncologist who's treating you, and then a second opinion to make that distinction of this is terminal or you are in a persistent vegetative state and are not going to recover. Once that determination has been made by those professionals, again, and that's dictated by Kansas law, you can't have it be just one, it's got to be two, and it has to be the treating doctor amongst them. Then you give the instruction of what sort of care do you want, either continued or withdrawn, or if there's care that you don't want to get. Things such as ventilators, feeding tubes, and other sorts of medical intervention. Again, what would you like to see done, not done, and what sort of efforts are individuals going to go to? Beneficiary designations are a great tool, and there's some assets that's really the primary way that we transfer them. Beneficiary designations are contractual agreements between yourself and the account or asset holder that designate what happens to the asset on your death. And these take priority and precedence over the instructions, maybe in a will or a trust or something like that. So these are also called transfer on death, pay on death designations. Another beneficiary designation that you see often with real estate and bank accounts is you'll see joint tenancy with rights of survivorship, which means that all the owners listed on that item, again, whether it's real estate or bank account, the survivor continues and takes full ownership. Again, oftentimes you see it with the spouses. So when the first spouse passes, the surviving spouse keeps 100% of whatever that asset is. Sometimes you will see it with siblings, but that's generally rare. Again, it's usually with spouses. Again, these bypass the probate process. The other place we see beneficiary designations used a lot are retirement accounts. These are tax advantaged accounts, and to avoid accelerating withdrawal and to stretch out the time period that those accounts have to be liquidated or withdrawn. And again, to avoid maybe creating a major taxable event in 1 year, those are typically distributed by beneficiary designations. And so the next generation or the spouse or whomever will take that as a retired 401k or retired IRA, and they have more flexibility in withdrawing or managing those and preserving if they're, pre-tax dollars, particularly that are put in there. These are used in conjunction with the gifts that are made in the rest of your estate planning documents. Sometimes they'll mirror exactly what your estate plan says. If you're giving equally to 4 kids, that may be what the beneficiary designation says. Sometimes it's a way to provide a little bit more for one individual than others, keeping the estate plan equal, and then the beneficiary on a particular account or property just goes to one. So again, it has to be taken into context with the overall estate plan. Everything works together, and it's one big dance and coordination. So what is probate? We talked about beneficiary designations avoiding this. We talked about trusts avoiding this. So again, and probate gets a bad rap. Everyone talks about how scary and awful and stuff like that, but that's part of the nature of it. So probate is the legal process by which a decedent's estate is administered and assets are distributed according to their will. Or again, if you don't have that will, according to what the state law says. Again, it's often considered to be costly, time-consuming, exposed to matters of public scrutiny. But again, that's often because probate is where things that are contested, to when there are problems, when there is conflict, that's where things head. The other reason is because, again, when you don't have a will, you end up in probate. When you don't have a will, you haven't communicated your wishes. So you'll have an estate where maybe you did a bunch of beneficiary designations and you thought, hey, all my assets are taken care of. I don't need a will. The bank, the car, the house, all of it has a beneficiary pay on death, transfer on death designation. There isn't anything else. I'm not going to do a will. Well, all those designations maybe give something to one kid and not to another, or maybe it gives it to a few of them and one's left out. But without a will or other instruction, you know, that heir, that beneficiary who is then not provided for starts to wonder, gosh, what happened? Where did things go wrong? Why am I not included? This had to be a mistake. And so those are the sort of messy things that end up in probate. Again, because probate is there when there's no plan at all, that's where a lot of its bad rap comes from. But again, probate can be a good thing if you want to utilize a testamentary trust. If you know there's conflict and there's just not a great way to avoid it, we'll put those instructions in and let it go through probate. Let the judge be there to help and protect your executor, who you have tasked to carry this out. Let them work with an attorney. Let them work with a court that will give them orders and authority to act and bless their actions. And if you don't anticipate probate, I'm going to go back just for a second. The other time probate can be useful, and you can do this in a trust as well, but if you need to liquidate real estate, if you have a significant amount of real estate, maybe you have a farming or ranching operation that isn't going to continue to the next generation, probate or trust can allow you to sell and liquidate that without maybe needing to get 6 kids to all agree on a set price, get their spouses on board to sign, prevent you from needing to get a dozen signatures to carry that out. So again, we can avoid probate altogether though, if perhaps you have one beneficiary, a single child or just a surviving spouse, or you're confident in the family's ability to effectively carry out your wishes without conflict. Avoiding probate, again, can really speed things up and make for a seamless transition. Again, this is very important if you have a farming or ranch operation. If you have a small business, we want to make sure that we are able to provide that continuality, that operations are not impacted, and that you have someone in place at all times to be able to make the necessary decisions on a day-to-day basis to manage that business or operation. So again, we can do that with beneficiary designations, a joint ownership with right of survivorship, or a trust. Again, everything goes into that trust bucket, and now that trustee just changes. And that's changed simply by the new trustee signing and accepting responsibility for the role. And there's essentially no break in the operations of that trust or a gap of someone having authority to manage that. So again, in Kansas, if you don't have and haven't utilized some of those and you're going to probate, you're going to work with Kansas inheritance law, talk about estate taxes in Kansas and elective share. So intestate succession, again, is laid out in the law, and you can see based on your situation, if you pass, where your property is going to go. Generally, it begins with the surviving spouse and children. But again, it's very important to know that, these are preferences that are in law, and what's in the law today, not that they change much, but the laws are subject to change, and it may not be what's in place 10 years, 20 years, 50 years from now when you pass. So under Kansas law, if you die, again, intestate or without a will, we divide it amongst your spouse and children. Your surviving spouse is going to get a portion, and the remainder is divided amongst the children. If you have legally adopted a child, under Kansas law, they have the same inheritance right as a biological child. If you have a stepchild who has a blended family and you have not adopted, then through intestate, so without a will, absent a trust, absent some other way of transferring assets, that child will not be would not be provided for as part of your estate. When we talk about the surviving spouse and the children are receiving it, your surviving spouse is going to get half of your estate, and then the children, 1, 2, 3, or 4, however many, will divide the remaining 1/2. So it's important for your spouse to make sure that you have designated accounts as jointly owned, made sure that land is going to transfer to them, bank accounts, things like that, because your spouse otherwise can suddenly be found with only half of the assets of the estate. And so particularly for smaller estates, this can really be an issue. We will talk a little bit, there's some elections, things like that. It's not really a true half because there's some property that we can accept out of there. And there's some elections that the spouse can make to increase their portion. But at a baseline, half goes to the spouse and half goes to the children. So a bit of good news amongst all the heavy talk, there is no estate tax in Kansas. So an estate tax and inheritance tax, there's nothing due based on the size of your estate when you pass, transfer those assets to your beneficiary. And currently the federal estate threshold is also very high and does not apply for the majority of people. Currently, the federal estate tax limit is just a touch under $13 million for an individual. So if you are, approaching that amount, we're going to want to make sure that as you go through that estate plan, we're making sure we're utilizing 100% of that limit, and we're not, maybe wasting assets that could be moved or rearranged to utilize more of that limit for each individual. This is particularly important for business owners, farmers and ranchers, particularly if it is a land or equipment or real estate heavy industry. If you have it all tied up in dirt or equipment or buildings and facilities, then that's going to require liquidation of something to satisfy those taxes. I will note that this limit expires at the end of the year. This limit was part of the Tax Cut and Job Act. They raised it, but it will expire December 31st of this year and drop significantly absent something being done with it. But again, there's no Kansas estate tax. Again, we talked a little bit, if you are bumping up to that $13 million threshold, there's a number of ways that we can do it. Again, gifting during your lifetime is one of the major ways, starting to shed some of that. There's lifetime limits though, so it's not overly helpful, but we can create irrevocable trusts, work on utilizing charitable donations, and things like that. But again, a big part of it is making sure, if you are, again, a married couple and you have a spouse, you each have that $13 million limit. And there's ways that we can make sure we maximize that for each of you, and that you each get that $13 million limit, or at least as much of it as we can possibly use. Elective share. So again, when we talk about intestate succession, this is one of those ways that the spouse can try and carve off a little bit more than half in certain situations. This is a dollar amount set by statute. In addition to the elective share, there's a homestead allowance that can be utilized to help protect the home of the surviving spouse so that that doesn't get wrapped up into that division. Next, how do we go about making an estate plan? First thing to figure out is, what do you have? Okay. Um, as part of that evaluation process, again, you want to determine, what are you really trying to communicate? What values are you trying to instill into uh, the next generation or your beneficiaries, whoever they may be? Are you trying to encourage investment in real estate, home ownership? Uh, are you trying to ensure long-term income streams? You know, how are you going to communicate, things that you have done and been important to you in your lifetime, and make sure that that's successfully transitioned to the next generation or other beneficiaries. Again, you're going to figure out who are the good, not only decision makers, but who's going to be organized enough, who's going to be able to handle the communication necessary with other beneficiaries, again, with anyone who is assisting with this process. Okay. And then pick those people and communicate to them, hey, would you be willing to do this? And then again, just little, you don't have to share documents with them or all the details or things like that. But again, what are your values? What are your beliefs? The next is to start drafting. So we're going to want to make sure that we draft a will. Again, this is that important safety net that should be part of all estate plans. And then we're going to consider the use of trusts. Again, there's dozens of types. Most people use regular revoking living trust. Again, that's a powerful tool and bucket to ensure that continuality. And there's no interruption there in management of assets. But again, that's not right for everyone. If you anticipate conflict, you could just be setting up your trustee for trouble. Once the rest of the planning documents are done and we've determined what you want to happen, how you want it to happen, things like that, then it's important to update those beneficiary designations. It's important to make sure that those match with your trust, to match with your will, that they mesh and coordinate with those things that you decided. This is also where you're going to want to make sure, if you have a trust, you fund it and put the assets in that you want to be in there. You do that by deeding in real estate, changing account ownership at banks, things like that. A regular living trust does not require you to get new account numbers, to get new checks, things like that. You're not going to have to go change all your automatic payments, but it does require you to retitle it with the various financial institutions. Communicate to them the name of the trust, who has the authority to act for the trust, etc. Again, you want to make sure you create healthcare directives. Do you want written instructions? Do you want that power of attorney to know how you want to be cared for? And these are going to change. Again, you're not going to, if you're a healthy individual, you're not going to be doing a do not resuscitate order. As things change, maybe you're in hospice, suffered a catastrophic injury, that may be something you want to revisit. And that leads right into the seventh. You're going to want to regularly review and update your estate plan. And again, this is a personal situation and is specific to everyone. There are certain milestones in life that would generally apply, but there's also changes in law. So if you're someone who maybe is flirting with that estate tax limit, as that changes and fluctuates, you're going to want to make sure that that's dealt with. Maybe your business is in some sort of heavily regulated industry. You're going to want to make sure that your transition and succession plan is going to allow for continued permitting and licensing of that business. You could have a beneficiary die. You could have a beneficiary become disabled. It's important that any benefits they receive, SSI, SSDI, things like that, they're able to continue to receive. And a gift from your estate doesn't disqualify them from receiving the services maybe that they have come to rely on. Again, we don't want to create a disruption for them. We want to ensure continuality with all of this stuff. So going through these again, knowing what you have, and this is a big part of the estate plan. And when we create a plan for individuals, you're going to get a small folder or binder that includes some extra documentation at the back. If people have a starting point, even if you don't keep it necessarily up to date, if they know, hey, the first place to go look is at this bank or at that bank, or this is the CPA, but putting together a list of those assets and accounts and things like that, it gives people a starting point to start tracking things down. Again, know who is going to serve. Okay, they have to be someone who's willing to say no. That's generally harder to say no than yes, particularly if your trust or will is going to hold assets for a longer period of time. People are going to be asking, can I get it now? Do I have to wait? Things like that. They have to be able to communicate fairly and firmly. This is what the wishes were. This is how the document is written, and this is how we're going to administer it. Again, and the during the life decisions are often as or more important. So make sure that your financial power of attorney and healthcare power of attorney are designated, that they're people who would be willing to serve. You don't have to tell them you put them in there, but it doesn't do you a lot of good if someone comes to them and says, hey, Janice can't make these decisions anymore, and she designated you, and you have no interest in it or don't know. A lot of people, when they get hit with that surprise, don't want to serve because they don't know how you want your stuff to be handled. Again, draft a will, communicate. You can name who's going to care for your kids, and again, a trust. So we can smooth that transition process and make sure that we avoid probate. Again, beneficiary designations, as accounts change, as things change in your life, you have children born, maybe a child predeceases you, grandchildren, things like that. You want to update these beneficiary designations. And then all of these documents only matter to the extent that people know they exist and have access to them. So if you have a living will and it's not on file with the hospital, it doesn't really help anyone. And again, this is a lifelong process. It's really not something that you can start too early. Obviously, no one is expecting an early demise or exit, but things happen. So particularly if you have, again, children or spouse or someone that you want to protect and care for, maybe it's a sibling that you care for and want to make sure is supported. Get this done and make sure it stays up to date with changes and events in your life. Again, we've talked about how important it is to have a will. So this is where we see issues. Again, just not having it, you don't have that safety net, and your wishes aren't communicated. Again, inadequate legal advice. Everyone's an individual. Everyone's got their own values. Everyone's got their own situation, what they own, what they don't. Don't think that because what you have is, maybe what you think a common situation or things like that, that you can use a generic form. Okay. Again, this really becomes important with anytime you're dealing with an account that may have tax implications. So again, retirement accounts, things like that, or especially if you are at that estate tax limit. And oftentimes you may not be at it now, but perhaps you're set to inherit. So right now that's not, but you're anticipating an inheritance that will then put you into that limit. You want to make sure you plan ahead. Not updating it, getting remarried, blended families, things like that. You want to make sure that that estate plan is changed. Uh, a child predeceases you. So, and overlooking your incapacity planning. Again, this is as much about your taking care of you as well during your life. This isn't just about the next generation. Got to take care of yourself first too. One of the things you can do in a will is select someone to care for minor children. So if you leave and the other natural parent has also deceased, this allows you to make sure that your first choice is recognized and looked at and evaluated by the court before someone else. So if you got a cousin that you really don't want involved or caring for the children, make sure that you've designated someone.
Strong, bud.
And part of that process, you can designate an alternate. So in all of these, you're going to have the opportunity
Did you?
to designate a number of people. Okay, again, beneficiary designations. We talked about these at length, but again, they come in a bunch of different names depending on type of account, the type of asset. So again, these are designations that typically, if you have a bank account that's pay on death, as soon as you get the death certificate back from the state, work with the funeral home on obtaining that. You can take the death certificate in and they'll pay out the account to who's ever named once they have a copy of that. So again, this is a very fast way. And again, these assets are outside of probate, which helps protect them and shield them from creditors and things like that. So again, some real world examples real quick. First one is, all of these are very common, but, married family with children. If you have an estate plan with a will, a trust, and powers of attorney, when one of the parents predeceases, the spouse is provided for. The kids know how to provide for the second spouse as maybe their health fails. And again, you have a will, so if forgot to put a tract of land into the trust, or maybe you inherited something after the trust was created and it never got added to the trust, that will is there to catch that asset and to make sure it's transferred. The other situation where estate planning is important, and it's important to make sure it's updated, is a blended family situation where maybe you have partners who each have children of their own from prior relationship. Things change, situations change, and we all want to think that our kids would continue to be provided for, but sometimes the surviving spouse or partner then takes and transfers the assets only to their children. So if you're the first one to pass, your children could be at risk, and you can avoid that through planning, through the use of trusts, either a living trust or a testamentary trust. You can make sure that a portion is set up and held or available for your kids. And then again, single person or a married couple, even with no children of their own, where are those assets going to go? Do you have a particular cause or charitable use that you'd like to see it? Do you have nieces and nephews that you're close to? In intestate succession, as families get smaller and thinner, um, there's less and less options for where some of that stuff would go. So I want to make sure, particularly when you don't have lineal descendants, that you got a plan so your assets don't go back to the state. Some resources. There's lots of stuff out there. There's a million sources on the internet. Um, you want to make sure you're using a trusted source. So the Kansas Bar Association has a number of pamphlets and information that cover different aspects of estate planning, explain in more detail what some of these various documents are. Kansas Legal Services also has some drafts or versions, particularly like the powers of attorney. They typically have uh, a version online of the uh, healthcare and the financial ones. Again, all of these are generic resources, though. They comply with state law, they meet the minimum standards, things like that, but they're not necessarily tailored to your specific situation. And particularly as conflict or the potential for conflict rises, that customization is important. Again, there are other things out there that are super popular. A lot of people like them because they're cheap. They aren't necessarily bad. Sometimes they work, but they don't always match with Kansas law. And then you really got a mess. So again, you want to make sure that you got something that works for you, because a bad plan is typically worse than no plan. You're setting everyone up to try and work with something that just doesn't make sense, or is confusing. Again, maybe doesn't even meet the requirements of the state law. So I'm going to wrap up and do some questions here in a second. But again, this is just for informational purpose. Your situation is specific to you, and it really is important to consult with an attorney. And it's important to find an attorney, again, who's going to want to get to know you and your family and your wishes. Um, this isn't and shouldn't be a cookie cutter process. And that's what a lot of attorneys and a lot of the online resources try and make this.